Good morning and welcome to East Brandywine Township. Today we'll be holding a special meeting for the Carlino East Brandywine LP preliminary final land development application. I'm going to turn it over to our solicitor, Kristen Camp, who will lead us in this hearing today, and we'll go with that.
Thank you. So this is a public hearing. It has been advertised pursuant to the Pennsylvania Municipalities Planning Code by public notice. I have previously circulated a list of proposed board exhibits, and they're basically everything that's been filed with the township, consultant review letters relating to the land development application that's before the board. We've given both parties an opportunity to add to that list if they wanted to, and I have added some additional exhibits at the request of BVA and L&R's counsel. So I'm going to go through that list now for purposes of the record. I've handed everybody a large binder that has copies of these board exhibits. If the exhibit was rather lengthy, such as a stormwater report or a transportation impact report, I did not copy the entire report in the packet I provided to everybody. I do have the original here behind me if anybody needs it. So this is, let me start by just giving a little bit of facts about the application. The applicant is Carlino East Brandywine LP. They are the equitable owner of property at 1279 Horseshoe Pike, which is identified as Chester County Tax Parcel Number 30-5-227. The applicant's plan also utilizes a 1.972 acre portion of a parcel 30-2-47 and a 0.069 acre portion of parcel 30-5-226. Those parcels were condemned by the township through a notice of condemnation that was filed in 2014. That condemnation has been upheld by the Commonwealth Court. Applicant seeks to build a shopping center and construct a public road through the eastern portion of the property to connect Horseshoe Pike and North Guthriesville Road. A portion of the public road and stormwater management facility are proposed on the adjacent parcels that I've just identified. They also propose improvements along Horseshoe Pike on land owned by the township pursuant to the declaration of taking. The proposed shopping center, stormwater management, and portions of the public road are located within the mixed use district, MU, mixed use. The remaining portion of the public road and stormwater management facilities are located within the R3 residential district. I'd like to mark the following board exhibits. B1, proof of publication in the Daily Local on November 30th and December 5th. Board Exhibit 2 is the preliminary final land development application. It was dated July 2nd, 2018. It was received in the township on July 3rd, 2018. Board Exhibit 3 is the preliminary/final land development plans consisting of 34 sheets prepared by Arna Engineering. They're dated June 27th, 2018, and the last revision date is October 16th, 2018. Board Exhibit 4, boundary and topographic survey, consists of 2 sheets. It was prepared by Langen Engineering and Environmental Services, dated May 19th, 2010, last revised August 25, 2015. Board Exhibit 5, Wetlands Delineation Report for the East Brandywine Center, prepared by Watershed Eco LLC, dated April 8th, 2015. Board Exhibit 6, letter dated November 7, 2018, from Arna Engineering, outlining the waivers that the applicant has requested for this plan. Board Exhibit 7 is a letter dated November 16th, 2018, from the applicant's counsel, Mark Kaplan, explaining the waiver request in more detail. Board Exhibit 8, Transportation Impact Study. This was prepared by Langen Engineering and Environmental Services, dated May 19th, 2010, last revised March 17th, 2011. Board Exhibit 9, Traffic Signal Report, prepared by Langen Engineering and Environmental Services, dated March 17, 2011, last revised December 8, 2016. Board Exhibit 10, Post-Construction Stormwater Management Report, prepared by Arna Engineering, dated June 27, 2018, last revised September 12, 2018. Also included with that is Appendix B, which is the stormwater conveyance calculations with a last revision date of October 16, 2018. Board Exhibit 11, Historic Property Documentation Report, dated October 19, 2015, prepared by, I believe, Robert Weiss Preservation Planning, LLC. Board Exhibit 12 is a memorandum from the Township's Historical Commission, dated October 15th, 2018. Board Exhibit 13, a letter dated November 8th, 2018, from Ebert Engineering Incorporated, with the planning module submission addressed to the Pennsylvania Department of Environmental Protection, and that planning module submission is also dated November 8th, 2018. Board Exhibit 14 is a sewer connection and reservation agreement with the municipal authority, and that is dated June 13th, 2017. Board Exhibit 15, a letter dated March 13th, 2018, from Langen Engineering and Environmental Services with a highway occupancy application addressed to PennDOT. Board Exhibit 16 is a PennDOT review letter of June 8th, 2018. Board Exhibit 17, PennDOT review letter of August 24, 2018. Board Exhibit 18, a letter dated August 30th, 2018, from Langen with the alternative transportation plan, which was also part of this exhibit, and that was also prepared by Langen Engineering, dated May 13th, 2011, last revised January 20th, 2012. Board Exhibit 19, NPDS permit approval dated July 31, 2018. Board Exhibit 20 is a Chester County Conservation District adequacy letter dated November 29, 2017. B21 is an Aqua Will Serve letter dated June 1, 2010, and a confirming email from Gary Horn dated November 5, 2018. B22 is the Township Engineer Panoni's review letter of November 2nd, 2018. B23 is the Township's Traffic Engineer Heinrich and Klein Associates, Inc., review letter of November 5, 2018. Board 24, Hydroterra Professionals, LLC review letter of August 31, 2018. Board Exhibit 25 is a letter dated November 29, 2018, from the East Brandywine Fire Company Fire Chief. Board Exhibit 26 is the Township Planning Commission minutes from November 7. Board Exhibit 27, Chester County Planning Commission review letter of August 8, 2018. Board 28, review letter from LTL Consultants dated November 1, 2018. Board Exhibit 29 is titled New Plan Objections. It was prepared by Paul Prince Esquire, representing BVA, and it was received on November 5, 2018. Board Exhibit 30 is a memorandum dated December 4th, 2018, from Mr. Kaplan in response to the new plan objections. Board Exhibit 31 is a letter from Heinrich and Klein Associates dated December 7th, 2018, and that was responding to the LTL Consultants letter of November 1. Board Exhibit 32 is a letter dated December 7th from Panoni, again in response to comments made by LTL in their November 1 letter. Board Exhibit 33, letter dated December 7th from Kyle Scribner, Chairman of the Board of Supervisors, consenting to the use of the township property on the plan. Board Exhibit 34 is a letter dated May 29th, 2018, from Orlando Law Offices to Francis Haney at PennDOT. Board Exhibit 35, letter dated July 23rd, 2018, from Orlando Law Offices to Francis Haney. Board Exhibit 36, emails from Francis Haney, dated July 31, 2018. Board Exhibit 37, email from Francis Haney, dated August 24th, 2018. And the final board exhibit that I'd like to mark at this time is Board Exhibit 38, which was a letter dated September 29th, 2018, from Heinrich and Klein Incorporated. So as I said, I had previously asked counsel for the applicant, Mr. Kaplan, counsel for BVA, Mr. Prince, and counsel for L&R, Jean Orlando, if they would agree that these exhibits could be admitted into the record, and that if the author of the document were called to testify, the witness would testify under oath to the truth of the statements and make the expert opinions set forth in the exhibits. Do all counsel consent to that?
I do.
Yes.
Mr. Prince?
Yes, ma'am.
Okay. Obviously, the amount of weight and credibility to give is up for the board, so that's not a decision that's made at this time. At this point in time, I do have, as I said I would, Nate Klein is here. He would be available for cross-examination if either party wanted to call him. Obviously, it's a very voluminous documentary record. The board has had these documents available. They either have already read them or will read them and consider them and give them the weight that they deserve. We'd like to limit the testimony to issues that maybe are not brought forward in the letters, or things that you need to clarify or cross-examine the author of some of the documents on. And the board has the ability to carefully review, and I think everybody did a very nice job of setting forth their legal positions on whether or not the plan that's before the board meets the code requirements, and therefore, that's really the issue for the board to decide. Does the current land development plan meet the requirements of the East Brandywine Township Code? And therefore, if it does, should the board be approving it? So let's focus the testimony on that, please. We will now, is there any preliminary matters that either party wishes to raise to the board?
One quick comment. I just want to note that the review letters that you put in the record are the last review letters.
That's correct.
There is a series of letters before that. That's just so that that's in the record.
And also, I believe that one of the board exhibits that I was asked to put in is Board Exhibit 38, which was a letter of September 29, 2018 from Heinrich and Klein. So that was one of the earlier ones, but I did not bring in all of the other Pannoni ones or all of the other Heinrich and Klein letters.
And before we get started, I also want to remind everybody of the rules of conduct for this meeting. We will be civil. We will keep it within reason. Any arguments will be decided and settled by the Board of Supervisors. If it does get out of control, I will give everybody one warning. One warning only. After that, you'll be asked to leave the meeting, whether you were finished or not, whether you have somebody here who is presenting a case for you. As you know, these have gotten very heated, and I understand that, but we also have professionalism to run in this meeting. Understood, everybody? Mr. Kaplan?
Yes.
Understood, Mr. Prince, Mr. Orlando?
Yes, sir.
Where's Andy?
He should be coming. Yeah, he'll be here. Okay, any preliminary matters that either party wishes for the board to consider?
Yes, ma'am.
Thank you.
If it please, ma'am, as you know, I had previously written you in your capacity as solicitor.
My apologies for the interruption. Mr. Prince, you have two options to be heard on the microphone for the recording. Either the lectern, there's an area mic, or at your seat, there is a mic. The one that you've chosen, unfortunately, won't record.
This one?
I would actually prefer, if you intend to stand, to stand at the lectern.
Sure. So, as I was saying, is that better?
Yes, thank you.
Okay. Now that we know that technologically we are functioning, I have previously addressed a request to you, Madam Solicitor, in your capacity as solicitor for the board, requesting that Mr. Fisher recuse himself. Mr. Fisher has not responded, as a result of which, in accordance with the law as I understand it, this is a matter that has to be brought before the board, and I would suggest to you that it is a preliminary matter and requires a preliminary vote before you can proceed with anything in this matter.
I don't
There is,
disagree it's a preliminary matter, but it's a matter that Mr. Fisher alone will make a decision on. It's not a board decision, in my opinion.
may I finish?
Yes.
With due respect, I don't think that's consistent with the law, but of course you can make whatever decision you want. I would suggest to you that this is not, as Mr. Fisher opined in his written response to my recusal request at the last hearing, a personal matter. It is not an issue of my personal feelings about Mr. Fisher, nor is it an issue of the manner in which he conducted multiple hearings. It is not an issue about rulings he may or may not have issued. He acted in those hearings in a proper fashion as a member of the Board of Supervisors and/or chairman, and it's not about that. It is about repeated, continuous, from the very inception of this application, bias and prejudice that he has exercised either orally or in writing in a manner and fashion that is not supported by the law. By way of example, you have, because you participated, a copy of the testimony of Scott Pearsall in the condemnation trial, in which it was evident from that testimony that Mr. Fisher engaged in numerous meetings with representatives from Carlino in violation of the Sunshine Act, that there were promises made and ultimately kept, that in addition, there have been comments he has posted exhibiting his viewpoint on the matter, recommending approval of Giant. There have been articles published in the newsletter of the township that have clearly evidenced a bias and prejudice in favor of Carlino. These are not the normal proceedings and the normal manner of someone who is adjudicating a matter. I'm going to tender you a list of some, not all, some of the items of bias and prejudice that we think exist in this matter and have existed in this matter. I also have for you a brief on the law, differentiating, if you please, between the legislative function and the adjudicative function. The decision by Mr. Fisher on his own in an adjudicative fashion is not appropriate with regard to the question of bias and prejudice. No response having been made, this is a matter now before this board. This board has to decide whether it is going to proceed. You're shaking your head, Madam Counselor.
We
I
will
understand
disagree.
you disagree
We
with me,
can
but
disagree.
I have the right to state my position.
And you are. I haven't interrupted you.
This board has to make that decision. This board has to decide whether it is ultimately going to allow a decision to be tainted by someone who has evidenced a decided viewpoint and engaged in improper conduct, including issuing approvals on behalf of the township and recommendations on behalf of the township that were never approved by the township. Mr. Pearsall testified that there was an approval issued of a recommendation by the township approving a grant application that Carlino filed when no such discussion, resolution, or approval appears anywhere in the minutes of the township because it didn't occur, as Mr. Pearsall acknowledged. That's only one example. I would suggest to you that, and all of these are matters of the township's own files and the township's documentation. I do have a copy of some of them with me, if you would like to see them.
Mr. Prince, if there's documents that you want to mark as your exhibits that you believe are relevant to the issue of whether Mr. Fisher needs to recuse himself, you need to provide those to the board. I mean, you can give us a list and we can get them later, but I'm not going to produce them. They're your exhibits that you want us to have. So, again, I think you have them in your possession or you wouldn't be able to speak to them.
No, I
So,
have some.
And again, we're happy to mark them, but you need to provide them at some point in time.
Well, I will take you up on that, and those that I do not have with me, I will see to it are subsequently provided to you. They are all listed and enumerated on the list that I will produce, and I'd ask that the list be marked as well as the memorandum of law.
Do you have that list now to
I
give me?
do.
Okay. All right, well, we'll mark it. Do you want to do this BVA 1? You're going to mark the BVA 1?
That's fine.
Why don't we have BVA 1 be the list?
And BVA 2, the memorandum of law.
Okay. And then we'll supplement, based on your list, the other exhibits.
Why don't you give it
Yeah,
to you?
he has one.
Yeah, since he's the person on topic.
We'll give one to the clerk recorder. So I take it from the court reporter's response that you're going to maintain the official exhibits, Madam Solicitor?
Yes. Yeah, I mean, I think it is a question. I want to go on record to say it's a question for you and you alone. And that you want to take another month and come back.
I'll tell him that. He's finished.
Mr. Prince, are you done with what you want to, argument you make on this?
On this particular point?
Yes.
Yes, ma'am.
Okay, so again, I mean, I actually read the same cases that you're providing in your memorandum, and I do think it is an individual decision of each board member as to whether or not they believe they have bias or prejudice. I do not believe that that's a decision for the entire board to make. I think only the individual who's being alleged to have the bias is the person that can make that decision. I do want to ask Mr. Fisher some questions, though, based on your allegations. Mr. Fisher, do you believe that you can listen to the testimony provided in the hearing with an open mind and fairly make a decision as to whether the plan should be approved?
I do.
Do you believe that you can conduct yourself in a fair and impartial manner during the course of these hearings?
Yes.
Are you affiliated in any way with the applicant or its proposed tenants?
No.
Do you have any financial interest in the applicant or any of the proposed tenants?
No.
Do you have any bias or prejudice against Carlino?
No.
Do you have any bias or prejudice against BVA?
No.
Do you have any bias or prejudice against Eleanor Partnership?
No.
Have you made any predetermined decisions with respect to the plan that is currently before the board?
No.
Do you recognize that the plan that is the subject of this application is a new plan, and that any prior decisions of the board on prior development plans for the Carlino Shopping Center have no impact on whether or not this current plan meets township ordinances?
I do. So at this point, Mr. Prince, you've provided some new material. I'm going to take it under advisement. I think I have to make a decision to recuse myself or not recuse myself before the board votes, but I'm going to participate in the proceedings.
May I move on?
Sure.
Secondly, Madam Chairman, anticipating that that would be your position, I must bring to the board's attention the fact that, as you are aware, you initiated a resolution and vote of the board at its meeting this month with regard to participating in the Carlino plan that is before you for adjudication. The board passed a resolution and issued a letter inter alia clearly stating that it was approving participation in the plan. I would suggest to you that it is impossible for this board to sit in adjudication fairly and impartially on a plan which it is now a party to. I know of no example in the history of Pennsylvania municipalities planning law, and I, of course, am only one individual, and I defer to greater wisdom that may be present in the room with regard to the municipality's planning code, but I know of no case where a board sat in adjudication on a plan of its own that was for the benefit of a private developer. We're not talking about the township voting and participating on a decision with regard to buying land for its own building or something of that nature. You have chosen to join an applicant on a private plan for a private development as an applicant. And I submit to you, as an applicant, you do not have the right to sit in judgment of this matter, and I urge you to agree to refer this matter to the Attorney General for appointment of an impartial board to hear the matter and decide the question.
Well, my advice to the board is, and we talked about this at the meeting, is that in this issue where the township, for a public purpose, condemned land to build a road that the developer has agreed to build, it's not improper for the township to consent to the plan being filed using land the township owns, which is the condemned land. There's nothing improper about the township consenting to having the applicant include that land on its plan. That doesn't mean that the township has predetermined and judged and said that, yes, the plan has to be approved. All it's consenting to, and the purpose of the letter that was approved on December 7th, B33, it's been marked, the whole purpose of that letter was because the applicant would not be permitted to file a land development plan with land it doesn't own without the owner's consent. So the
Madam-
purpose of that letter was to show that the township consented to that land being included on the application.
Madam,
That does not, let me finish, please, Mr. Prince.
sorry,
That by consenting to the use of the land for the application for the construction of a public road which benefits the public, which has been upheld as being a public purpose, does not, in my opinion, render this board improper or biased or to the point where they can't render a decision on the land development plan. The burden that they have is to make sure that the totality of the development plan, the part that Carlino owns, the part that the township owns, everything that's shown on that plan has to comply with the township code and township ordinances. That's what this board has to be able to render. So if you want me to question all of these board members to determine if they're If they have bias or prejudice because of the fact that part of the land that's part of the application includes township-owned land, I'm happy to do that. But I don't think that it raises to that level. I've never, ever heard of the Attorney General having jurisdiction to appoint somebody to hear a case on whether a land development plan gets approved or not. So that, you'd have to provide me case law on that, because I absolutely have never seen that. Never seen that. And again, I think you're reading into B33 a lot more than what it is. So again, it's gonna be a board decision, but my advice is that you as a board do have the power to be able to hear this matter and render a decision.
Au contraire, Madam Solicitor, you have misstated the matter. You're doing it intentionally because we have discussed this repeatedly. This is not about a road. This is not about a stormwater basin for the road. I know you are familiar with the plan. I know that you are aware of the fact that part of the proposal of the plan is to run a private sewer line through almost half of the property you condemned from L&R, a private sewer line and a private stormwater disposal line. Those are running through your condemned land and have nothing to do with the road, have nothing to do with the stormwater basin for the road. I am not questioning the right of this township to say we do not object to you ultimately building a road through our land that we condemned if the plan is ultimately approved. That's fine. You had the right to say that, but you didn't say that. What you did was pass a resolution participating in the plan as presented, and that plan, as you know, contemplates the private use of public land contrary to statute.
Objection.
Now, one thing,
Objection.
excuse me?
Objection.
Objection in the middle of my comments?
Objection.
Mr. Prince, you can finish your argument, and then I'll
Thank you.
turn it over to Mr. Kaplan to respond.
Even Mr. Kaplan, in his commentary that he submitted in November, responding to my objections, recited again the statute in question, Section 310 of the Eminent Domain Code, and that statute's very clear. It effectively says, and there's case law on abandonment, and what you have done, whether you realized it or not, by that resolution is effectively abandon that acre of property through which you are allowing a private party to run a private sewer line. That private sewer line is exactly the issue that the Pennsylvania Supreme Court spoke to in the RCRA case. And what the court said was it didn't matter that the water line in that case was capable of being used additionally by other members of the public, or that the developer may have intended to do that at some point in the future. The line itself was a private line, and this sewer line is for the Carlino development. It is a private sewer line that you are authorizing by your participation to run through public land that the law says if you're not going to use it for a road, you have to give back to my client. With due respects, the statute is very clear on your obligation to turn back to us first, within 10 years of the date of condemnation, any land that you are not using for the stated purpose. And if you look at the township's declaration of taking, and that's the critical document here, the declaration of taking that the township issued says that the land is being taken for a road and stormwater facility for the road, not for a sewer line for Carlino.
Okay, we heard your argument. Mr. Kaplan, do you have a response to that argument?
I'm sorry?
Do you have a response to that argument?
I don't have a response to that argument. I have an objection to what is being done now. Everything that Mr. Prince has said is already in the documents. And the premise of this hearing was that we were not going to rehash all the arguments that have been made in the papers. And this has got to stop. This is my application, and Mr. Prince cannot be permitted to hijack it with arguments that he made before the Commonwealth Court and he lost. But I don't want to have to respond because I think it's totally out of order.
Well, Mr. Kaplan, in an abundance of caution, I don't want a court to remand it and say that we should not have considered this preliminarily. I have had email exchanges with Mr. Prince about this particular issue, and I will tell the board that I disagree from a legal perspective. I think that it was an issue that was raised in the condemnation preliminary objections, and I think the Commonwealth Court overruled it. I have received guidance from Jack Larkin, who's been representing the township for many, many years on this case, and specifically the condemnation. And I've reviewed Mr. Prince's allegations with Mr. Larkin. I've also done my own independent analysis, and I disagree. I don't agree that whether there's a private sewer line running through land that was properly condemned, I don't think that means the land has to be abandoned back. And I would recommend that the board rule against this preliminary matter and agree that the hearing can continue.
I think that, I mean, obviously I've raised the issue that, about the public sewer line going across because it was not in the verbiage in the declaration of taking. And I believe early on, back in January, I had asked Jack Larkin what the specifics were in a requirement for a second-class township road. And he had said that a second-class township road had to be 50 feet wide, and the township could not take more than 120 feet wide for the road when it was done being constructed. So that leads me to question what the whole triangle was used for, specifically for the taking, and Jack responded that there's not really anything
No,
to
that's,
use that land for.
okay, so,
As I understand it, the narrow issue before us right now is whether
having a
the,
private sewer line.
no, it's the letter that we recently did, I forget the date of it, letter dated
December 7th,
December
B33.
7th, permitting the applicant to include facilities on property that we own as a result of the condemnation results in a disqualification of the entire board.
Well,
That's the,
he's saying that's not the issue. He's saying
no,
the
that's what
issue
he,
is,
that's what he got up and said, right, exactly.
is that the issue, Mr. Prince? Because you told me I said it wrong.
Mr. Fisher is a lawyer, and Mr. Fisher succinctly said what
Okay,
the
well,
issue was.
That's, I
All
think,
right, so I'll make a motion that we deny his motion to disqualify the entire board on that grounds.
And I'll second. All in favor?
Aye.
No?
okay, we may move on. Any other preliminary matters before we start the hearing on?
I have two, very briefly. First, on behalf of L&R Partnership, I join in the motion asking Mr. Fisher to carefully consider whether or not he should recuse himself, because I believe the information that I've seen in the past would indicate that he should recuse himself at this time. And I respect the fact that he's going to consider the information that's been submitted and that he'll make a decision before voting. I just want to make it clear that I join in the motion to encourage Jay to please consider doing that. I think that's the proper thing to do. The other thing that's preliminary, and this won't take long, but the prior to the date of this hearing, I requested that the board provide to me blank subpoenas for use in the production of witnesses and documents for this hearing, and that was not afforded to us. And I want to provide as what I've marked as L&R 1, which is the request that I submitted to Attorney Camp, the blank subpoena form which I submitted, and then there was an exchange of emails because Kristen was on vacation at that time with her partner Tom Ost, who requested the legal authority under which I thought the subpoena should be issued, and I responded to that and provided the legal authority. I want to make a brief offer that the subpoenas would have been used to compel parties and witnesses to produce documents that we believe are in their possession that would have a definite impact on the appropriateness of some of the issues that are going to be considered under waiver request. And if you want to hear more, that's fine. I can make other offers of proof. Right now, I understand the subpoenas weren't issued. We didn't receive them. I don't want to belabor the hearing. What I do want to do is, because these subpoenas were not provided to us and we did not afford them the opportunity, it's my position that our clients here are not being afforded all of the procedural and substantive due process to which we are entitled. All I want to do is preserve that issue for a later time. I don't want to make a big deal about it. I don't want to argue about it all morning long, but I do raise that issue now preliminarily, and I want to submit the exchange of email requests as my first exhibit in order to preserve that issue.
Mr. Orlando, I did review the emails you sent to Mr. Esty, and I did not see a citation to any law that says that a Board of Supervisors sitting in an adjudicative capacity ruling on a land development plan has subpoena power. I did not see any law on that point. I told you that if you showed us some law, I'm happy to reconsider the decision. So what law is it? You have the floor right now. Tell me what the law is.
I submitted to Mr. Oates an email which I believe provides the legal authority for the township supervisors to issue that subpoena.
So you are,
Respect the fact that you disagree, and like I said, I don't want to make a, I'm not trying to.
well, but you're claiming that you're lacking, you know, the board's going to, you're not going to have fair due process if we don't issue subpoena, and I don't want, my concern was that if this board doesn't have the power to issue a subpoena, somebody who receives that subpoena is thinking that I've given the opinion that we do, and without having clear legal authority to do that, I wasn't comfortable having the board issue a subpoena. The second part of our dialogue was that I asked you for who specifically you wanted to subpoena, so that we had an offer of proof to understand that those witnesses would be providing relevant testimony as to whether or not this plan meets the township codes. You refused to provide that information to me, saying you didn't have to. Well, then, I can't take it much further. I mean, I would go so far as to, if you had told me who you were trying to subpoena, I would have made a phone call on behalf of your client to say to the person, hey, would you mind coming to this hearing? They believe that your testimony is relevant. You wouldn't do that. You refused to tell me who you wanted to call, so the dialogue stopped there. Yeah, so,
On behalf of BVA, I join in the motion.
okay, well, we have your information. We have Eleanor 1.
I do, I guess, while
I would like to make just one comment. I responded in an email to you, Kristen, our view of the limited amount of due process, if any, to which Eleanor is entitled to in this proceeding. My client, Carlino, has a property interest in this proceeding and is entitled to due process, and this board is giving us due process. The two property owners do not have a property interest in this proceeding, and if they did, the United States Supreme Court has said that due process is a relative concept and it is not fixed. And what you have done, in my view, by having us submit all of the materials in advance and marking them in the record so that this board can review the relevant evidence is due process for both of us. So on behalf of Carlino, I object to this demand for subpoenas for unnamed people. If anybody's due process would be harmed, it would be our due process to do trial by ambush by giving Mr. Orlando a subpoena to unnamed people.
Do you want to mark the email that you sent to me? I have it, I just have to grab it and get the date of it.
Yeah, if you do, I would like to mark
All right,
it.
well then, you'll have to give a second for me to find it.
Thank you.
Hang on. I want to make it very clear with regard to the issue I'm trying to preserve here. You're making a phone call to someone who has a document that they do not want to produce is not the issue. As an example, it is our belief, based on references in other documents that we have seen, that there's a Del Val soils report in the possession of Carlino that would undercut in a very significant way the information now being presented on the ARNA plan. So obviously, since Carlino has that, and they don't want to show that because it would undercut this particular plan, you making a nice phone call for me and saying, won't you please bring that Del Val report, is not going to help us. The issuance of a subpoena would. You made two responses, one of which was substantive to my request. You said you didn't have the authority. I suggest you have the authority under both the second-class township code, the municipality's planning code, and most importantly, as I said in the email, under local agency law. Your asking for witnesses to show up that have documents that they may not want to produce is not relevant to whether or not you have the authority. The second issue with regard to individuals involves the state program director with regard to communications in this matter that have not been uploaded to the PennDOT portal as part of the highway occupancy permit. And again, I didn't want to go down all this road. I simply wanted to make an issue, put it on the record as to the fact that you did not issue subpoenas and that we believe that that has impaired our ability to present relevant evidence on the issue that's before us.
I'm going to disagree with you that unless we know who it is that you intended to subpoena, who you expected this board to subpoena, and what documents you expected them to produce, and then for the board to make a determination.
I would have
as to
issued
whether or
a
not-
subpoena to Peter Miller to provide the Del Val report that was produced in 2010 and in 28. I would have subpoenaed Francis Haney to provide email communications between himself and township representatives that may have addressed the issue of Mr. Fisher or township predisposition
Mr. Orlando,
as a minimum.
Mr. Orlando, when Solicitor Camp told you that she did not believe that the board had the right to do the subpoenas, that would have been the first thing I would have asked for. I would have said, well, then can you see if you can get these documents for us? But to bring them up day one of the hearing, in my opinion, is too little too late.
And you have the right to have that opinion, sir.
Okay, your position is noted for the record.
Thank you.
Madam Solicitor, may I ask a question of you? And that is, bearing in mind the conversation that you just had and the ruling, and I'm not challenging that, there are documents that will come up in these proceedings. Am I to understand that on its face, unless there is some evidence to the contrary, we will not go into issues of authenticity? And
I don't have a problem with the board.
will determine,
Yeah.
based on the evidence that is provided to us. However, if you are giving us something that's already been discussed in previous conversations, hashed over, no, we will not. We
with
will,
respects, that's not what I'm asking.
I think you have to ask Mr. Kaplan. He's he's the opposing party. The board is sitting as the judge here. So, I mean, I don't have an issue with the board taking, not having an objection as to authentication. It depends on what document it is. I can't say that without knowing what document you're talking about. But, I mean, I think that was what we had talked about as far as preliminary. But again, we have to do it on a document-by-document basis.
Well, I'll tell you, for instance, I have an email of Thomas Waters that I intend to introduce that's relevant to these proceedings. I would have subpoenaed Mr. Waters, but in light of your decision, I did not subpoena him. Now, the document is clearly, the email, it's addressed to a lawyer, and the lawyer responds. It is the entirety of the document that was produced in discovery.
Well, Mr. Prince, it's not your case yet. Why don't we wait till it's your case?
Well, but
And
you
at that
asked-
point in time, if,
By way of example, that,
Please, I would like to present my
Yeah.
case. Enough of the hypotheticals. Please cut this off and allow me to present my case.
yeah, I think as far as the issues you just raised, we'll have to wait till you're presenting your case. And at the time, Mr. Kaplan will have the opportunity to raise an objection. Mr. Kaplan, please proceed.
Thank you. If you don't mind, I'm going to sit. Carlino East Brandywine LP is the equitable owner of an undeveloped tract of land located at 1279 Horseshoe Pike in East Brandywine Township, Chester County, Pennsylvania, containing approximately 10.118 acres. The property is zoned mixed-use commercial and is located to the west of the existing Brandywine Village Shopping Center. We are here today in connection with a preliminary/final land development plan application submitted by Carlino East Brandywine LP on September 12th, 2018. As this board knows, this is not the first land development plan submitted by Carlino. The development of this property has had a long and tortured history. Since 2010, Carlino has submitted land development plans to build a 51,525 square foot supermarket with a 9,250 square foot expansion area and a 4,600 square foot attached retail building. Its earlier plans also showed a pad site for a bank. In this latest application, the bank pad site has been eliminated. From the beginning, the township insisted that Carlino's application provide for the construction of a connector road through the property and connecting with both Horseshoe Pike and North Guthriesville Road. All of Carlino's land development plans submitted since 2010 have shown the connector road in a location that was dictated by the township.
Objection, ma'am. That is not consistent with any evidence that's ever been presented.
What is this?
in
This
these
is my
proceedings.
opening statement. Please direct this man to be quiet.
Mr. Secretary.
No,
Madam Solicitor, first of all, I'm not this man. I know Mr. Kaplan.
Mr. Prince, he's making an opening statement.
I understand he's making an open statement, and I have a right to object to a statement that includes matters that are not factual and not of record anywhere.
Then you can point that out when it's your case.
Just a simple objection and then note it, and then we'll move on, and then you can bring it up after.
That's all I asked.
On November 17th, 2014, the township filed a declaration of taking, condemning those portions of the BVA property and the L&R property needed for the construction of the connector road improvements. The declaration of taking also condemned and extinguished certain easements that BVA contended it possessed over areas of the Carlino property, which easements were located where the township wanted the connector road improvements located, and which interfered with the construction of the connector road improvements. BVA and L&R filed preliminary objections to the declaration of taking, which the Court of Common Pleas dismissed by order dated September 8th, 2017. I have handed to everybody a binder of documents. A copy of the court's September 8th, 2017 order is included in the binder that I have handed out behind tab 1. The Commonwealth Court affirmed the Common Pleas Court's order on July 2nd, 2018. A copy of the Commonwealth Court's July 2nd, 2018 order is included in the binder behind tab 2. Despite the Common Pleas and Commonwealth Court's decisions affirming the township's declaration of taking and dismissing BVA and L&R's objections, BVA and L&R continue to contest the township and Carlino's right to construct the connector road. We believe that their continued assertions that the township and Carlino do not have the right to construct the connector road improvements are patently frivolous. As you also know, Carlino's plans for the proposed development have been subject to much litigation. The reason this is relevant is because Carlino's plans have remained substantially unchanged since the first plan was filed back in 2010. On August 8, 2011, this board approved Carlino's first land development plan for the proposed development and granted many of the same subdivision and land development waivers and modifications that Carlino now seeks in connection with the current application. The first plan showed the connector road in the same location that is shown on the current plan submission. However, at the time the board approved Carlino's first plan, the township had not yet condemned the land, easements, and right-of-way necessary from BVA and L&R to construct the connector road improvements. Therefore, on October 12, 2012, the Court of Common Pleas issued an opinion and order which reversed the board's first plan approval solely because the first plan showed the connector road improvements over the L&R property, which Carlino did not own. The court rejected all of BVA's other grounds for appeal. The October 12, 2012 court order is included in the binder behind tab 3. On December 8, 2014, Carlino submitted a second preliminary plan application to the township. The second plan was identical to Carlino's first plan with only 3 minor variations. Number 1, based upon the township's declaration of taking, the second plan identified the township, rather than L&R, as the owner of the area encompassed by the connector road improvements. Number 2, the second plan did not identify the BVA easements since they had been condemned and extinguished. And 3, the second plan depicted the connector road as a private driveway through the Carlino property, which would connect to a proposed public road to be located on the L&R property, which would extend to North Cuthrysville Road. On January 21, 2015, this board granted conditional preliminary approval of the second plan, which approval was memorialized in a written decision dated February 3, 2015. The board's second plan approval also granted many of the same saldo waivers and modifications that Carlino now seeks in connection with the current application. On February 20, 2015, BVA and L&R appealed the board's second plan approval and filed a motion requesting that the second plan be remanded to the board based on the township's purported failure to provide written notice of Carlino's second plan as required by the township ordinance, which remand was granted by the court. In accordance with the court's remand order, the board held a proceeding to allow BVA and L&R to present reports, testimonies, and exhibits on the second plan. On October 1, 2015, the board issued a revised decision with regard to Carlino's second plan, which denied approval of the second plan based on certain hyper-technical issues asserted by BVA and L&R in their second appeal. On January 6, 2017, the Common Pleas Court issued an opinion and order which affirmed the board's revised decision, but rejected all of the other grounds that BVA and L&R had raised in their appeal. A copy of the court's January 6, 2017 order and opinion is included in the binder behind tab 4. The Commonwealth Court affirmed the Common Pleas Court's order on January 5, 2018. A copy of the Commonwealth Court's January 5, 2018 order is included in the binder behind tab 5. On October 21, 2015, Carlino submitted to the board a third preliminary plan which addressed the technical issues the court identified, the board identified in its October 15, 2015 revised decision. The third plan was substantially identical to the second plan, except that it corrected the deficiencies that served as the reasons for the board's denial of the second plan. On April 22, 2016, the board approved Carlino's third plan, and again, granted many of the same saldo waivers and modifications that Carlino now seeks in connection with the current application. On May 20, 2016, BVA and LNR appealed the board's third plan approval to the Court of Common Pleas. By order and opinion dated July 18, 2017, the Common Pleas Court rejected all of BVA and LNR's arguments and affirmed the board's approval of the third plan. A copy of the court's July 18, 2017 order is included in the binder behind tab 6. On August 5, 2017, BVA and LNR appealed the court's July 18, 2017 order to the Commonwealth Court. By opinion and order dated April 19, 2018, the Commonwealth Court reversed the board's approval of the third plan for one reason and one reason alone. It found that the connector road was a road rather than a private driveway, and therefore that the location of a proposed bank violated the required setback from a public road. A copy of the Commonwealth Court's April 19, 2018 order and opinion is included in the binder behind tab 7. It is important to note, however, that the Commonwealth Court addressed, pardon me, the substance of all of BVA and LNR's other asserted grounds for appeal and rejected all of them. So that history brings us to the plan that is the subject matter of this hearing. Carlino's fourth plan, which is both a preliminary plan and a final land development plan. The fourth plan is nearly identical to all of the previous plans submitted. The only substantive changes made were to identify the connector road as a road rather than a private driveway, and to eliminate the bank pad, which encroached into the required setback. The fourth plan was reviewed by a new township engineer, Nate Klein of Pannoni Associates, Andy Heinrich, the township's traffic engineer, Hydroterra Professionals, the township's stormwater, the township's sewer consultant, the township's fire chief, the Township Historical Commission, the Township Planning Commission, the Chester County Planning Commission, the Chester County Conservation District, and PennDOT. All of these review letters have been placed into the record by the township, and I thank Kristen for doing so. BVA and LNR's consultant, LTL, has submitted 2 review letters, and we have submitted our responses. Mr. Prince has submitted his, quote, new plan objection, and we have submitted our responses. All of these documents have been placed into the record by the township as well. We believe that the documents submitted into the record by the township, as well as the court orders and opinions that we have submitted, establish that Carlino's preliminary/final plan development application satisfies all of the requirements of the township zoning ordinance and all of the requirements of the SALDO, with the exception of those requirements we have sought waivers or modifications from. So our intent is to now present testimony needed to support the waivers and modifications we are seeking. We will rely on all of the documents that have been included in the record as related by the solicitor. I would like to call Shirag Thakar as my witness with regard to the waivers and modifications.
Mr. Kaplan, do you want to mark this binder that has all these decisions you just went through as Carlino 1, just so we have some way to identify it?
Sure.
Would that be appropriate?
Yeah, that's fine.
Okay. Thank you.
I thought we were going to mark as Carlino 1 our response to
The email? Okay, I don't have that with me, so that's fine. We can do that. So Carlino 1 will be an email communication that came from Mr. Kaplan to myself, and we will find that before the day is over and provide it to opposing counsel. But that addressed what due process rights they believed BVA and LNR had with respect to this process. So that will be Carlino 1. Carlino 2 will be the entire binder of cases that Mr. Kaplan just summarized. Please proceed with your witness.
Thank you.
And Jen, please let us know when you need a break. Thank you.
I do.
Would you please state your name for the record?
Shirag Thakar.
Do you have his spelling? Great. Chirag, please explain your educational background for the board.
I have a bachelor's degree in civil engineering from India and a master's degree in civil engineering from Rutgers University.
Are you a licensed professional engineer in the
I-
Commonwealth of Pennsylvania?
I am.
Since when?
2007.
By whom are you employed and in what capacity?
Your Honor, BVA will stipulate to his credentials as a licensed engineer.
Thank you.
Thank
So
you.
we'll accept him as an expert?
Thank you.
Is that LNR
join in
BVA?
that, yes.
Okay, thank you. We appreciate that.
Okay.
Please proceed.
By whom are you employed and in what capacity?
I'm a principal at Arna Engineering.
And are you the project engineer for the proposed development?
Yes, I am.
Did you prepare the land development plans for the proposed development?
Yes, I did, or under my supervision. I was involved with the project from the initial 2010 application, when I was employed with Langen Engineering.
Now, I'd like to go over the waivers and modifications that Carlino is seeking in connection with this land development plan application. Please look at a letter dated November 16th that the township has marked as B6.
B6 is actually November 7th letter from Arna. The B7 letter was from you, November 16th.
Okay, let me just get those straightened out.
And I have an extra exhibit binder if you want me to provide it to the witness.
Okay. So B6 is,
Chirag.
you're right.
Anybody can use this.
November 7th. I apologize for that wrong citation.
You can just leave that on the.
Yeah, just leave it up there. Thanks.
Shrug is the November 7th, 2018 letter from you, the most recent waiver request letter submitted on behalf of Carlino.
No, November 16th letter is the most recent one prepared by your office.
Okay. Then let's use my letter of November 16th. So we're going to go through each of these waiver requests. Thanks, Luke. Let's start with the first one, which is a request for a waiver from section 350.24. B, Paren 3, Romanet 1 of the Saldo, which requires that all information required in section 350-24B be shown within the property and within 300 feet of any part of the property proposed to be developed. First of all, has all of the information required by section 350-24B been shown for the development site?
Yes, it has been. The waiver request is for some of the information that is required beyond the property, but within the 300 feet of the property.
Okay, let's break this down. First of all, what aspects of the required information were you able to show with regard, were you able to show on the land development plans with regard to the properties that are within 300 feet of the development site?
So we were able to show the existing streets and their dimensions, existing buildings, topography of the general area, and certain utilities within the right-of-way.
What information were you not able to, excuse me one second. Yeah. And what information is not available to you without going on to adjacent properties?
The information that is not available is a sewer and sewer systems located on individual lots, certain utilities such as gas, electric, transmission lines, fire hydrants, source of water supply, whether it's public or private well, things like that, easements, areas of any special deed restrictions, things of that nature, related to that particular property.
When you say that particular property, that's a property other than the development site?
Correct.
Was this waiver requested in connection with any of the prior plan applications submitted by Carlino?
Yes, it was.
Objection, Your Honor. What was done in the past is irrelevant to this plan. It's a new plan that stands on its own four corners.
I join in that objection.
I do agree this is a new plan, and this board has to make its own ruling on waivers. If he believes it's relevant to point out that it was granted before, the board will give that whatever weight it deserves.
But, Madam Secretary,
There's been a
Yeah.
ruling.
Mr. Prince, that's the
There's been a
ruling.
ruling. I'd like to continue.
how can it be relevant to a new?
Moving on.
Moving on. It's overruled. It's overruled. They'll
Moving
give,
on.
we recognize that this board has to make its own independent decision.
Not necessary.
When someone tells you twice and you continue to talk over them, this is our hearing, not yours, Mr. Prince. Continue, Mr. Schrock.
So yes, it was requested and granted during each of the previous plan approvals.
I think I didn't ask you a question that I should have asked you, Sharon. So tell us why you can't get that information.
Some of the information, the information that I just noted, which are relative to the individual lots, is physically not possible to get that without stepping on those properties.
And we
And
don't
we
have
don't
the
have
right.
rights to do those.
Thank you. Let's move on to the second waiver request, which is a waiver from section 350.24. Capital B, Paren 3 of the Saldo, which requires, when applicable, submission of a, quote, shadow analysis showing the location of existing trees and new trees and screening and shadows cast by the proposed structures and mature landscaping at 9 a.m., noon, and 3 p.m. on the date of the winter solstice. End of quote. First of all, is this section applicable to the proposed development?
No, this application, in my opinion, is not applicable to the proposed development because this is usually applied to an urban environment. The proposed plan shows one-story structure located well internal to the site and meeting the requirements of the zoning ordinance in terms of heights, et cetera. There are also trees planted along on the landscape plan, which is a requirement of the zoning ordinance. Again, it's a buffering requirement.
And why is not the shadow analysis applicable with regard to the trees?
The closest structure from a property line is about 60 feet away. So the closest structure from the proposed structure is approximately 200 feet away. So these proposed structures and landscaping are located well internal to the site, and they meet the requirements of the zoning ordinance. So it's one-story structure. You can't build less than one-story structure.
And therefore, based on what you've just told us, any shadow that would be cast would not be cast on any building on any adjacent property?
Yes, that's my estimation.
Okay. So then, if this section is not applicable, why has Carlino sought a waiver?
Carlino is seeking a waiver in abundance of caution should the Board of Supervisors determine that this section is applicable.
And was this waiver requested in connection with any prior plan application submitted by Carlino?
Yes, it was for each of the previous plans and was approved by the Board of Supervisors.
Okay, let's move on to the
I'd
third.
I'd like to just make one note. I'll just concurrently go along as we touch on each waiver. Just to put on
Please.
a record that if either Nate or Andy has supported the waiver or have no objection to it. In this particular instance, Nate does not have any reservations on that.
Objection to what Mr. Thakkar thinks Mr. Klein or anyone else.
Yeah, and I would
has-
sustain that, and I don't think we need it anyway, because Mr. Klein's letter, I was gonna say Mr. Pannoni, excuse me, Mr. Klein's letter is in the record anyway, so.
Well,
Objection is-
That was, I'm sorry, that's what I was referring to.
well, but I do want you, if you would, point to the letter of Mr. Klein. Tell us the date of the letter that you're referring to, and address the paragraph in that letter that corresponds to this waiver, and just read what Mr. Klein said.
Mr. Kaplan, I don't think that's
Objection.
necessary. That's exactly what we were trying to avoid. These guys have these
Okay.
letters, and they've read them.
Okay,
We don't need them to reiterate it and repeat
Okay.
it. Thank you.
let's move on to the third waiver request, which is a waiver from section 350.34, paren capital A, quote, vertical street alignment, end quote, which requires that where the grade of any street at the approach of an intersection exceeds 4%, a leveling area shall be provided no greater than 4% for a distance of 40 feet measured from the nearest right-of-way line in the intersecting street.
Mr. Kaplan, your letter has a 350-34E, not A. Is it E?
It's E.
Okay.
If I
You
said
had-
A, I
You said A.
apologize.
I just want to make it clear.
My apology. Now, first of all, explain this to us, and then tell us, why don't you explain this to us?
If I may, can I roll the
I'm-
plan?
I'm
so-
sorry, I asked you the wrong question. Please point out to the board the area that this waiver relates to.
Sure.
So the plans have been marked B3. So the full set of plans, please confirm that those are dated the same that I have marked B3. Dated June 27, 2018, last revised October 16th, 2018.
That's correct.
Okay, so he is showing B3 up on a projector overhead, and everybody has a reduced size copy of B3 in their binder packet. Thank you.
I'm gonna speak up a little bit so that she could get me. Oh, I'm sorry. I'm so sorry, I didn't realize that. Okay. All right, so the waiver, there is,
Would you tell us what sheet it is?
I'm sorry, the drawing number 20.00, sheet 5 of 34.
20.00?
Drawing number 20.0. So this section of the code is referring to the drive, the right-out drive, and I'm just pointing with my finger, coming out of the front parking field of Giant onto Horseshoe Pike.
Okay, let's start with this. Do you believe that a waiver from this requirement is necessary?
No, I don't believe so. The reason is that it's, that the section deals with the street intersection, not intersection of a driveway and a street, which is what the case is here.
Then why is Carlino seeking this waiver?
Carlino is seeking this waiver because Judge Nagel, in his October 10, 2012 opinion, directed Carlino to seek this waiver. That is the only reason.
And if a waiver from this requirement is necessary, please explain to the board why you can't comply with this requirement at this right-out driveway?
So as I had mentioned, the section is not applicable in my opinion, but should this be applicable, the reason we cannot comply is that the existing site, and I'm gonna flip to drawing 03.00, which is the conservation plan, sheet 2 of 34. And I'm gonna point to an area where the proposed right-out driveway is located. It's right about in this area. And if you see the grades, the existing grades, difference between Horseshoe Pike and the subject site, it is approximately 4 to 5 feet lower than the road. The site today is 4 to 5 feet lower than the road. When you put the driveway in, which necessitates the higher slope on the driveway.
I'm sorry, Shrock, I didn't hear what sheet you were showing now.
This is 03.00.
Thank you.
Am I loud enough?
I have hearing aids and I don't hear well, so
No
my
problem.
fault.
So just finish that. The grade of the property is 4 to 5 feet below the road. What would have to be done in order to comply with this requirement?
In order to comply with the requirement, the parking lot, the proposed parking lot and associated building would have to be raised to try to level it to Horseshoe Pike elevations.
And
What it does as a result of that is, and I'm gonna flip to a grading plan, 21.01, which is sheet 8 of 34. What it does by lifting the site up, including the building and the parking lot, the rear access drive, which is just on the backside right here, which serves the Giants loading area, will be at a higher percentage slope than what is currently shown on the plan, which would then trigger a waiver at that location.
Okay. Was this waiver requested in connection with any of the prior plan applications submitted by Carlino?
Yes, it was during the last two applications, and it was granted by the Board of Supervisors.
Did either Mr. Heinrich or Mr. Klein comment on this waiver request?
Objection to what they commented on.
I just asked them whether they commented. I
Yes.
didn't.
Yes. Mr. Heinrich commented on the.
And could you just tell us what letter and what paragraph?
Again, we don't need to go over that. We have those letters in the
Oh,
record.
okay.
Okay.
We have
So-
those letters.
I just want I want the board to know, there's a whole series of comments from Nate and.
They have those letters, Mr. Kaplan. They've
Okay.
reviewed them.
Okay. Let's move on to the fourth waiver request, which is a waiver from section 350.40.C entitled Drive Grades, which requires the grade of the driveway intersecting a street not to exceed 5% within the legal right-of-way or 14 feet from the edge of the shoulder, whichever is greater. Please point out to the board the area that this waiver relates to.
Coincidentally, this is the same location that we went over in the prior waiver. This is the driveway, the right-out only driveway coming from Giants' front parking field onto Horseshoe Pike.
Please explain to the board why you can't comply with this requirement at this right-out driveway.
As I just mentioned during the prior waiver, the only way to really deal with it is to raise the site. So if you raise the site, what you do is you frustrate the effect onto the other sections of the code, namely the rear driveway, which is supposed to be the truck access driveway would get significantly steeper and therefore require a waiver there because it will exceed 5% in that area.
Was this waiver requested in connection with any of the prior plan applications submitted by Carlino?
Yes, it was.
Let's move on to the fifth waiver request, which is a waiver from section 350.40.N, capital N, Paren 2. Now, this requirement applies to site driveways and requires minimum radius of 30 feet. Please point out to the board the area that this waiver relates to.
So I am going to flip to drawing 20.00, which is sheet 5 of 34, labeled as site plan. The two driveways, the two curbs on the driveways where this modification, in fact, is requested is for the curb movement on the right where I'm showing, on the right-hand side of an exiting movement from the BVA driveway, that curb is at 25 feet. And the next one is the right movement coming out of the rear of the BVA property onto the proposed connector road. That is at 25 feet. All other curb radii either meet or exceed the 30-foot radii requirement. 20.00.
I'm sorry?
20.00. Sheet 5.
I'm there. Please explain to the board what would happen if Carlino...
Excuse me, Mr. Kaplan, are we looking at B3? Here's my 2000, it's not
Wait,
my
wait,
drawing.
5, he said. Sheet 5?
Yeah, drawing number 20.00, sheet 5.
It doesn't match. Mine does. Oh. Yours matches, mine doesn't. This is not the right drawing. Here. Here's the book. Lest there be any question that I'm misstating. There it is. And look what's up there. Clearly is not the same sheet.
Okay, but what's the point?
I don't know why that wouldn't be.
The point is,
He's entitled to know what he's reading.
Well, the drawing is on the board above us.
How about that one?
It would be nice if he had a copy.
I mean, there've been so many versions submitted, I want to make sure I have the right version here in my book.
Yeah, I can't tell, I mean,
I don't understand why you're saying, oh, it's not shaded in the back.
No, it's a different drawing. There is a drawing that I've seen in the past with that shading, and obviously it exists, he has it up.
Mine's not
It appears to
shaded.
be the same drawing, it's just there's some
Shading,
shading
yeah.
difference.
I mean, mine does show shading. I don't know if it's just because these were duplicated so many times, the shading got lighter, but we can make sure that we have the original plan set that he's testifying to be the official record.
Just, if we can, Chirac, what's the date on that drawing?
Original date is
You guys don't have
6/27/18,
shading?
last revised is
Same, it's the same.
10/16/18.
The same? It's just not the shading?
It appeared, I mean, it is consistent with that drawing, so
Okay. I think it's a matter of just the photocopying and the number of copies that were made, that the shading, the toner didn't pick up the shading as deeply.
Probably right. Shirag, tell us again what waiver, or I shouldn't say waiver, what modification is being requested in this request?
The modification requested is to propose a 25-foot radius on two curb turns, namely the one that I just described, one coming out of the BVA's front entrance drive turning right, and the second one being the rear entrance drive turning right. That curve radii is 25 feet. Proposed 25 is required 30 feet.
Tell us what would happen if Carlino was required to comply with this requirement?
In order to comply with this requirement, the configuration and the location of the proposed connector road would need to change, which has been determined by the township. The curb radii would encroach within the BVA's property. And it is likely that it is a movement of the road may not fit within the condemned portion of the property on the rear side.
And the radius could be increased if BVA consented to a modification of that driveway. Is that accurate?
That is correct.
And to your knowledge, has BVA refused that request?
That is correct.
Let's move on to the sixth waiver, which is a waiver from section 350, 47, capital B, Paren 2, which requires all subdivision and land development applications to be self-sustaining relative to the storage and disposal of treated sewage effluent. Is this section applicable to the proposed development?
No, it is not, in my opinion.
Why is that?
Because the proposed development is being serviced by public sewer, for which I understand there is a planning module approved by DEP and the township. And as such, as a result, there is no effluent that is anticipated to come back to this site. So there is, if the effluent isn't coming back, there's no reason to provide the disposal areas.
So then why is Carlino seeking a waiver from this requirement?
In abundance of caution, just in case, if
And-
Board of Supervisors think that it is applicable.
And what is your justification for the grant of this waiver?
As I just mentioned, the sewer from this development is conveyed and treated by public sewer. There is no effluent that is, post-treated effluent that is planned to come back to this site. Since there's nothing coming back, there is no reason to provide the storage and disposal area for this particular property.
Well, hypothetically, what would happen if somehow the sewage effluent came back? What would the effect be?
The effect would be, the plan would have to be revised in a material way,
And why is that?
because you would need the areas on the site to dispose the sewage effluent that is anticipated for, if in a situation that it comes back, you'd have to have the area to dispose that sewer.
And what would be the most obvious area to do that?
It would be subject to a field test, a septic test, and a sewer engineer would determine where the best location would be, based on the absorption of the soil and things like that.
But your testimony is that if this requirement were applicable, there would have to be a significant redesign of the site. Is that correct?
Yes,
Was this waiver requested in connection with any of the prior plan applications submitted by Carlino?
yes, all of the previous plans and the board had granted this waiver.
Is that a, you say when,
Excuse me.
can I interrupt to ask a question? Well, I thought we were doing as we go.
If it's relevant to what he just said, it might make more sense to
Go
raise
ahead.
it now. But
Go ahead.
can you
That's
speak
what I
up,
thought we did.
Jason?
I
Yeah.
thought we agreed.
That's fine.
Is that how you want to do it? I
That's
can wait.
fine.
I can
I think
write-
it's easier because now we're talking about this, but make sure you
I'm
talk loud.
fine. I didn't know.
I didn't,
that-
well, I can do
Go
either
ahead, no,
way.
go ahead.
As far as the effluent not being brought back to site, isn't that a requirement, though, of our ordinance to dispose and have effluent come back to your site? Because I know, like, NVR is being required to have 1.5 times their land set aside for effluent, based on last planning commission's meeting. So I'm just,
So you're asking him to give a legal opinion?
That's the ordinance would be us.
I'm asking if our ordinance requires
That's why they're
both.
asking for a waiver.
Yes.
Yeah, I mean, he's claiming it's not applicable. I think it is applicable. I think they need a waiver. So,
I'd like to point out to the board that the court, in its July 18th, 2017 opinion and order, affirmed the grant of this waiver.
Objection.
so
However,
noted. We understand the objection. It was the same point before,
however,
right? It's the same point before, that you don't think that waivers that were granted before have any relevance to this board.
No, ma'am.
We understand
This-
that.
No, ma'am. This
So
goes-
noted.
This goes to his reference to a court opinion and his interpretation of the court opinion.
The court opinion,
The court
Speak for
opinions
itself.
in the binder are not relevant to these proceedings, but he hasn't moved them, so I'm not objecting yet. But this reference to what a court did or didn't do on this point is not relevant.
well, I
to
think,
these
Mr. Prince, the
proceedings.
court, I think this board can take judicial notice of prior decisions. I think that they have the ability to do that. So I think that, again, to the extent the board thinks there's something relevant in those decisions, they have the right to take judicial notice of that. I would advise the board that to the extent a prior board or prior court upheld a waiver, we'll give that whatever weight we think it's merited. It's not dispositive of the issue of whether a waiver should be granted on this plan.
Problem with going down that road, and I understand.
there's
your-
been a ruling made. Please,
May I finish?
please stop Mr. Prince from continuing to argue after a ruling's been made.
Yeah, I would agree.
Point something different out.
Well, it's my case. Point it out in your case.
Then I have a separate objection, Madam Solicitor. Mr. Kaplan's statement is not factually correct. In fact, since we're talking about prior waivers, you will see if you consult the township records that in fact this very issue was the basis of the board's overturning its prior decision in dealing with the 2016 plan that went before the Commonwealth Court.
Okay.
The board itself decided that this particular section was applicable and overruled the prior decision.
Okay, let me do it this way. These court orders, the board can take judicial notice of. To the extent that when the board is ready to make a decision, we feel that it's relevant to look back, we will do so, and we will cite in the decision why we think it was or was not relevant. We don't need any more argument on it. We don't need any more reference to the prior plans, waivers been granted, or courts disposing in a certain manner. They're aware of those facts, okay?
Fine by us.
Okay, please move forward with your next waiver request.
I'm going to move on to the seventh waiver request, which is a waiver from section 350-24, point capital B, Paren 2, which requires a four-step design process. Is this section applicable to non-residential developments?
This section is primarily applicable to the residential cluster development option. I'm going to read a section I'm going to read a paragraph from this section where it is relevant to the land development application. It says, an application for any other subdivision or land development where no common area, no common open space is to be designated shall be required to demonstrate compliance with this process to the maximum extent feasible. Land to be set aside for recreation and/or to be left undisturbed shall be located and planned on the same basis as common open space under the four-step design process.
Now, the saldo permits an applicant to pay a recreation fee in lieu of providing recreational open space. Is that correct?
That is correct, under section 350-50B.
And as it did in the previous plan submissions, Carlino proposes to pay a recreation fee in lieu of providing open space recreation land on site. Isn't that correct?
That is correct.
So then is section 350-24B, Paren 2, applicable to the proposed development?
Not in my opinion, because there is no recreational land being set aside to apply the four-step process to.
Okay. And if hypothetically this section is applicable, why can't Carlino comply with the, quote, four-step process?
The location, the site is restricted by multiple things: the road, geometry of the property lines, topography, and most importantly, the proposed connector road, which is, with the location of which was determined by the township through previous grant approvals. And the location of that road dictates the design of the site primarily. So in order to comply with this requirement, you'd have to fundamentally change the plan and the location of the road. What it would also do, it may create a compliance issue with other sections of the code, namely road grades, setbacks, parking, etc.
Was this waiver requested in connection with any other prior plan application?
Yes, it was requested during all the previous plans, and the Board of Supervisors had granted the waiver.
Let's move
And-
on, I'm
And
sorry.
BVA had not appealed that grant of the waiver previously.
Let's move on to the 8th waiver request, which is a waiver from section 350-54, capital B, which requires that a, quote, subdivider plant street trees outside the right-of-way at 40 feet to 60 feet apart and staggered along both sides of the street. First of all, is Carlino a subdivider?
No, Carlino is not a subdivider, as there is no subdivision proposed. So this, in my opinion, this section does not apply. Additionally, I'd like to read a section of the same waiver request. It says, "The streets shall be planted by the subdivider outside the street right-of-way, but as close to the street line as is practicable to avoid conflict with right-of-way function and with side distance, while still permitting clear orientation of the streets to the streets. Such trees shall be spaced 40 to 60 feet apart, staggered along both sides of all but commercial street." The street in question, where we are requesting this waiver, is a commercial street.
And is excluded from this requirement by the section you just read?
That is correct. Section 350-54B.
So then why has Carlino requested this waiver?
It is an exercise of caution just in case if the Board of Supervisors deemed it to be applicable.
Okay, getting past applicability. And if this section is applicable at all, why can't Carlino comply with this requirement?
And I'm going to flip to the landscape plan, which is sheet number 10 of 34. The reason that we cannot comply with this section of the code is we cannot plant trees outside the right-of-way because we don't own the land. And I'm pointing to,
Bring the
I'm
po-
sorry, I'm pointing to the rear portion of the proposed connector road. This, what I'm running my pen over is the right-of-way line. The code requires the trees to be located outside the right-of-way line, which would put the tree on BBA property, LNR property.
Okay, I understand that one. Now, is there another portion of the site where this provision is being asked to be waived?
Yes, so what we have done is we've simply moved the trees on the southern side of the connector roads, on the rear portion of the LNR piece. However, due to the existing topography, artificial pond, wetlands, and a need to comply with the stormwater requirement, the trees are being planted within the right-of-way.
So on one side, you can't plant the trees outside the right-of-way because we don't own the right-of-way, and on the other side, you need to plant the trees within the right-of-way to stay out of the stormwater management facilities, wetlands, and the like.
That's correct.
Let's move on to the 9th waiver request, which is a waiver from section 345-311, capital D, Paren 12 of the Stormwater Ordinance, which requires the discharge as well as the emergency spillway, dam breast areas, or water storage areas of a detention basin to be located no closer than 75 feet from the original property line of the parcel being developed or any new property lines that are created. Why is Carlino seeking a waiver from this requirement?
So the reason the Carlino is seeking a waiver from this requirement is related to the existing natural resource, which is the wetlands and the artificial pond. And I'm talking about basin number 2 right here, so I'm gonna use the same plan. Basin number 2 is bounded by proposed connector road, existing North Guthrie'sville Road, artificial pond, and a wetlands. It's physically not possible to provide 75 feet buffer or separation between the lot lines associated with the road and still comply with the stormwater requirements.
And I think the one thing you didn't point out is the actual stormwater management facility, detention basin.
Right there.
Okay, and
It's
this.
triangle shaped.
And this requirement, this section would require that that detention basin be 75 feet from the new road, from the connector road, and 75 feet from Guthrie'sville Road.
And the rear, that's correct, as well as the rear property line of the PVA shopping center.
And for the reasons you've said, that's not possible.
Correct. The other basin, which is basin number 1, which I'm just pointing to, which is located behind Giant, is the existing topography of the site is that is the lowest point of the site.
Jim, point to where the lowest point of the site is.
So this area where I'm running my pen over is the lowest point of the site, which drains areas upstream towards that basin, which then flows downstream after treatment.
So you are pointing to an area on the northeastern corner of the Carlino property.
That is correct.
And you've got a northern boundary adjacent to the L&R property, and you have the connector road on the eastern side.
That is correct.
And you're saying that that detention basin has to be located in that location because that's where the water flows naturally.
That is correct.
And therefore, the basin cannot be located 75 feet from the road or 75 feet from the L&R property line.
That is correct.
Okay. Now, was this waiver requested in connection with any of the prior plan applications submitted by Carlino?
Yes, all of the previous applications and was granted by the Board of Supervisors.
Let's move on to the 10th waiver request, which is a waiver from section 345, 311, capital A, Paren 3 of the Stormwater Ordinance, which requires that all open channel slopes be no steeper than 1 vertical for every 4 horizontal. Why is Carlino seeking a waiver from this requirement?
So the reason Carlino is seeking a modification from this requirement is due to the limited right-of-way available within the condemned property. So I'm pointing to the north side of the proposed connector road on the rear portion of the property within the LNR condemned piece. There is simply not enough land available to provide a swale at 4-to-1 slope and still maintain the geometry of the road. It's physically not possible.
Do you have the drawing that you're,
Yeah,
like with all the
I'm pointing to
stormwater?
I'm
Instead of
pointing-
using landscaping plan, do you have one that has,
The
this-
grades are shown on both of them, it matter.
I can't read that. I don't know what plane you're on. What plane are we on?
The other area where the swale
I have the
exceeds
big
the
font.
4-to-1 slope,
Wait a minute, hold up. let the,
big set right here. Jason?
Yeah, but if we're
you want
talking about
this?
stormwater, wouldn't it be easier just to look at stormwater?
Look at stormwater, the same information is there.
It's just easier,
Because this is the big set, if you want to, it's probably much easier to read on this. What sheet are you on?
I now moved on to sheet 8.
What one, I'm sorry?
It's hard to read on this.
Thank you.
Help you. Sure.
Can I continue? So the other location where,
Wait a minute. You say sheet 8? 8. Thanks.
so the other location where this waiver is requested is along the southern side of the proposed connector road adjacent to the DDA shopping center. So, and the reason why we have chose to put a 2-to-1 slope versus 4-to-1 slope is that there is a sidewalk that is proposed adjacent to connector road. Right adjacent to the sidewalk is the retaining wall. And having a 4-to-1 slope reduces the height of the wall and therefore is a safer design. It still does the conveyance job as if it was a 4-to-1 slope. It still functions from a stormwater point of view. It's just a better design.
I think you, excuse me one second. I think that you might have used the word "for" in descriptions of both the before and the after. Would you just repeat the slope along the sidewalk you just talked about?
Yeah, so the proposed slope is at 2 horizontal to 1 vertical. Code requirement is 4 horizontal to 1 vertical. So that is the modification you're seeing.
And if you, is there a safety issue involved in this?
Yes, in my opinion, since the sidewalk is adjacent to the retaining wall, and the downside of the retaining wall is where the swale is located, it is a better design to have as less of a wall in terms of vertical height as you possibly can. With the 2-to-1 slope that we are proposing, reduces the height of the wall, and therefore is a better design, versus if you were to strictly comply with the code and you had 4-to-1, the drop from the sidewalk to the swale would be much higher.
Okay. So there are two aspects of this waiver or modification in the two different locations that you've referred to.
That is correct.
Mr. Kaplan, I'm going to call recess at 11. So I just didn't want you to lose your point of thought. If you have questions, we can continue at 11, and we'll stop at 11 for a 10-minute recess.
In that regard, Madam Solicitor, or whoever wants to answer it, what time are we planning to break for lunch?
I was thinking maybe sometime around 12:30 we break for lunch. If we do an 11 o'clock break.
Okay, so let me see if I can finish up on this particular waiver. Was this waiver or modification requested in connection with any of the prior plan applications submitted by Carlino?
Yes, it was, in regards to all the prior applications, and the Board of Supervisors had approved it,
Okay.
or granted it rather.
Let's move on to the 11th waiver request, which is a waiver from Section 345, 311, capital B, Paren 10 of the Stormwater Ordinance, which requires the stormwater system to be designed to produce a minimum velocity of 3 feet per second when flowing full, maximum permissible velocity to be 10 feet per second, and pipe slopes to be minimum of 0.5%. First of all, explain this and tell us what it applies to.
So what it means, or what the code requires, is to have 3 feet per second velocity in a pipe when the pipe is flowing full. The other requirement is to not have more than 10 feet per second of velocity in the pipe. The third requirement is a minimum slope of a pipe, the pitch of a pipe as to how you lay it, and that is at 0.5%.
Okay, so now we understand what the requirement is. Tell us what the waiver request is.
So the waiver request is, it's, the plan meets the 0.5% requirement. The plan also will meet the 3 foot per second requirement if the pipe were to flow full. Unfortunately, there are other sections of the code that require a spread of flow calculations, etc., which requires us to have additional inlets. Therefore, the water, enough water doesn't get into the pipe to have the pipe flowing full.
Okay, let me stop you there. My understanding is that the other section you referred to is a prohibition on the water spreading from an inlet or over the ground more than 4 feet. Is that correct?
Correct.
And are you saying that in order to comply with that requirement, you have to put in more and more inlets, and the velocity is not made in all of those inlets?
Yes, that is correct, because you end up with so many pipes, it's a branch of a tree, if you will. There's so many input feeds coming into this pipe network that those last sections don't get enough water. However, strict compliance with the code, theoretically, these pipes will carry the water at more than 3 feet per second, had they been full, which is what the code says. It says flowing full. In a hypothetical situation, if these pipes flow full, they will comply on the 3 foot per second requirement. There are 2 instances where the velocity of the pipe does exceed slightly more than 10 feet per second, and I can read you some numbers. It's about 10.93 in one section and about 10.45 feet per second in another section. And if the Board of Supervisors were not inclined to grant this modification, we could augment the design to bring the velocity within 10 feet per second.
What would you have to do to augment the plan?
We would have to, well, multiple options. We could play with the slope of the pipe, still have more than 0.5% minimum required, but have something less than what is proposed. That may be able to cure that. Increase the size of the pipe is another option. So, again, I just want to emphasize the modification we requested is very insignificant, but if that's not what supervisors want to grant, we could cure it.
And in your opinion, does the design that you've presented comply with generally accepted engineering standards?
Yes.
Do you have an opinion as to what the best design is?
In my opinion, I think exceeding the 10 foot per second by a 0.45 foot per second or 0.93 foot per second is relatively de minimis. Specifically, when the water that is flowing through the pipe eventually comes out of an outlet pipe into the basin, where there are ripraps, which is a stone bed, which slows the velocity of the water down and prohibits erosion. So there are controls placed downstream of the pipe to cure for this sort of thing. I would prefer to have pipe on a steeper slopes, personally, than on a shallower slopes, because gravity is doing the work and nobody's paying the bill. It works for us. So that's my personal opinion.
Was this waiver requested in connection with any of the prior plan applications submitted by Carlino?
Yes, it was, and supervisors had granted this waiver.
Let's
A
move.
modification, rather.
Thank you. Let's move on to the 12th waiver. Let's move on to the 12th waiver request, which is a waiver from section 345, 311, B12 of the Stormwater Ordinance, which requires all storm pipes to be laid to a minimum depth of 1 foot from the subgrade to the top of the pipe or the crown of the pipe. Tell us what this is and where does it apply?
So there is one pipe that does not meet this requirement, is the pipe that crosses across and under the proposed connector road. And the reason we cannot meet with this requirement or need a modification is the existing topography of the LNR piece is existing. It is what it is. We have limited right-of-way to do our grading and install the pipe. But we still need to drain the north side of the LNR piece over to the south side underneath the road. And we are tying into, we have two restricting points. One is the downstream side where the artificial pond is, and the upstream side where our limits of the right-of-way are with the condemned piece, and the geometry of the road. So in between these restrictions, what we have done is we have actually proposed twin 12-inch pipes. Rather than have a large pipe, we've gone as small as we can, and it's called out to be an RCP pipe, which still does the conveyance job. It just doesn't get to the requirement.
So it's not physically possible to meet this requirement.
That is correct.
Was this waiver requested in connection with any of the prior plan applications submitted by Carlino?
Yes, it was requested during each of the previous applications, and Board of Supervisors had approved it, and I believe BVA did not appeal from the grant.
Let's move to the 13th waiver request, which is a waiver from Section 345, 311, capital B, Paren 7 of the Stormwater Ordinance, which requires the curb inlets to be placed at curb tangents and maximum amount of encroachment of road runoff and the maximum amount of encroachment of runoff on the roadway pavement to be no more than 4 feet wide during the design storm event. So again, please explain this requirement to us and tell us what waiver you're requesting.
So the design requirement is that when it rains and water runs along the road, the code says that that run of water, the spread is what we call in an engineering term, should not be more than 4 feet. And the other part of the requirement, there are two requirements baked into this section, is to not provide inlets along the radii of the curbs. Now, the reason, and the waiver that we are seeking is related to the inlets along the radii of the curb. And the reason we need this is because of the very reason that you have to control the spread of flow, meaning the spread of flow can't be 4 feet. In order to keep that 4 feet band of flow, no more than 4 feet, you need multiple inlets. The code requires 30-foot radius, as we just talked about in the prior waiver. You are forced to put inlets along the curb in order to control the 4 foot of spread. So that's the hardship.
So in order to comply with the maximum 4-foot spread, you've got to put inlets along a radius.
Radius of a curb, that's correct.
Was this waiver requested in connection with any of the prior plan applications submitted by Carlino?
Yes, it was.
Is Carlino also seeking this same waiver with regard to the inlets on Horseshoe Pike?
So yes, so Carlino is seeking the waiver from the same section along Horseshoe Pike for a spread of flow. However, Horseshoe Pike is under a PennDOT jurisdiction, and the PennDOT standards on spread of flow are different than the code section, the Saldo sections. So we are complying with the PennDOT standards, and PennDOT has reviewed the drainage report, and so far they have not made any comments. So we are seeking a waiver to the extent it is applicable to the roads within PennDOT jurisdiction and outside the township right away.
Let's break here, Kyle.
All right, so we'll take a 10-minute recess. We'll start it back here at 10 after 11.